So picture this. You show up to the same government office every single day, use their computers, sit at their desks, and your boss is a federal manager. You're doing work that's absolutely essential to the mission. But here's the catch. On paper, you're not an employee. You're a contractor, and you're stuck in this legal gray area where your rights are, well, they're not clear at all. Today, we're going to get into the story of hundreds of government contractors who lived this exact reality and what went down when a government audit blew the lid off a system that was completely off the rails.
Okay, so let's really get to the heart of this thing. On one side, you have your official government employees. They get the whole package, right? Retirement benefits, all the labor rights, and overtime pay under the Fair Labor Standards Act. And on the other side, you've got independent contractors. They're hired for a specific job, they're supposed to have more freedom, but they have way fewer protections. The entire system is supposed to have a really bright, clear line between the two. So what happens when that line just gets completely blurred?
And that question brings us to a specific agency, the Broadcasting Board of Governors, or the BBG. You might know them as the agency that runs things like Voice of America. So back in the early 2010s, their own internal watchdog, the Office of Inspector General, took a deep dive into how they were hiring contractors. And what they found, well, it was absolutely explosive.
You see, the law here is actually super clear. For contractors who are basically working just like employees, totally integrated into the agency, there's a special kind of contract for them. It's called a Personal Services Contract, or a PSC. And to make sure agencies don't abuse this, Congress gave the BBG a hard, strict limit. They were allowed to have no more than 60 of these contracts. That's it, 60. That was the line in the sand. But when the auditors started digging around, the reality was just shocking. An official at the agency estimated that the BBG had somewhere around 660 contracts that were, for all practical purposes, these personal services contracts. I mean, they didn't just cross the line, they blew past their legal limit by more than 10 times. The agency was essentially running a massive shadow workforce.
And here's the real kicker. The government has its own checklist for what makes someone an employee. It's right there in the regulations. It asks simple questions like, are they working at the government's office? Are they using government equipment? Is their supervisor a government employee? Is the work they're doing a core part of the agency's mission? For a whole lot of these BBG contractors, the answer to every single one of those questions was a loud, clear yes.
So when the Inspector General's report finally came out, they didn't mince words. Their conclusion, right there in black and white, was that the whole contracting system was broken. They said the overwhelming majority of the people the agency was calling independent contractors were almost certainly misclassified.
And the problem was way bigger than just misclassifying people. The audit uncovered a total systemic breakdown. We're talking violations of the Anti-Deficiency Act, which basically means they were spending money they weren't authorized to spend. They weren't getting competitive bids for contracts, there was $3.5 million in costs they couldn't even justify. And the oversight for all of this? Pretty much non-existent.
All right, so with all this going on, how does it all turn into a huge legal fight? Well, armed with this incredibly damning government audit that basically proved what they've been feeling for years, hundreds of these contractors decided to sue. Their argument was really simple. If the government treated us like employees, then it should have paid us like employees, and that especially meant overtime.
The whole case was built on one very important law, the Fair Labor Standards Act, or the FLSA. This is the bedrock law that says most employees have to get paid time and a half for any hours they work over 40 in a week. The contractors were arguing that, since the BBG treated them just like employees in every way that mattered, the agency had to follow the FLSA's rules on pay.
But here's where it gets tricky. Joining an FLSA lawsuit isn't as easy as just signing your name on a list. It's a very specific two-step process. First, a formal complaint has to be filed with the court. Okay, simple enough. But second, and this is so important, each individual person has to file their own separate written consent to join the lawsuit. The legal clock on their claim for back pay doesn't actually start ticking until both of those steps are done. So now you have this mountain of evidence from the government's own auditors. You'd think that government's lawyers would have to argue the facts, right? Defend the agency's actions? Well, that's not what happened. Instead, the Department of Justice built a powerful legal defense that wasn't about the facts at all. It was all about highly technical legal rules.
The absolute foundation of their defense is a legal concept called sovereign immunity. And to put it simply, it means you can't sue the U.S. government unless the government says you can. And when it does give you permission, like it did with the FLSA, that permission comes with a very strict, non-negotiable rulebook. Think of it like a giant legal shield. You can only get past it if you follow every single instruction perfectly.
And one of those super strict rules is the statute of limitations. For a normal FLSA claim, you have just 2 years to file your lawsuit. Now, if you can prove the violation was willful, meaning the government knew it was breaking the rules, that deadline gets extended to 3 years. But if you miss that deadline, even by a day, your claim is what they call time-barred. It's just over, game over.
And this isn't some new argument. The government's position, which is backed up by decades of Supreme Court cases, is that these rules have to be followed to the absolute letter, they have to be strictly observed, there's no wiggle room, you can't ask for an extension because it seems unfair or because you didn't know the rules, the conditions are absolute, period.
Which brings us right back to that two-step process. The government's lawyers argued that a lot of the contractors, even though their names were on the initial complaint, failed to file that second mandatory written consent form before their 2 or 3 year clock ran out. It's a procedural technicality for sure, but when you're up against sovereign immunity, a technicality like that can be absolutely fatal to your case.
But the government's defense didn't stop there. They also attacked the very idea that all these contractors could sue together as one big group. They asked a really fundamental question. Are all these people truly in the same boat? Are they similarly situated?
And their argument was pretty powerful. They pointed out that this lawsuit had grown way beyond just the BBG. Now it included contractors from totally different agencies, like the National Institutes of Health and the Social Security Administration. I mean, you had broadcast journalists, hearing reporters, IT specialists, all with different jobs, different supervisors, and totally different contracts. The government's point was that figuring out if each one was really an employee would require hundreds of individual mini-trials, making one giant lawsuit impossible to manage. So what we're left with here is this huge clash. It's a battle between the documented, systemic failures of a government agency on one side and the rigid, often unforgiving laws that say how you're allowed to hold that agency accountable on the other.
Just think about the imbalance for a second. On one hand, you have a detailed official report from the government's own investigators that lays out years of misclassification and mismanagement. And on the other hand, you have these powerful legal shields like sovereign immunity that could get the whole case tossed out on a technicality before a judge ever even gets to hear the main argument about whether these workers are owed back pay.
And this leads us with one final, and I think really provocative question that goes way beyond just this one case. When an organization's own watchdog exposes that the system is fundamentally broken, can the rules of that very same system ever really provide a fair solution for the people who were harmed? It's a massive question about what accountability really means, and whether a broken system is even capable of fixing itself.